for only for today because I have got a my lord DB matter hearing
13.
13. It's a appeal of 2012, my lord.
Yes, that's the problem.
Any day, my lord. Day after tomorrow also.
Wednesday? Wednesday?
Yes, my lord.
As prayed for by Mr. B.M. Chaudhary, learned counsel for the appellant on grounds of personal difficulty today, relist, give Wednesday's date. Conference.
Oblige, lordship.
Yes,
I beg to mention, my lord, in respect of item number 26, unfortunately, from my file, copy of the original petition is missing.
26.
24. So, I may be, my lord, permitted
You are for the,
a copy from the registry.
you are for the,
Respondent, man.
who is for the petitioner?
Mr.
Have you taken his consent?
I am not praying for adjournment.
Oh, acha, acha,
Or a
acha.
copy, my lord. My
Yes, yes, please. Second copy. You want to go through?
Yes. No, my lord. I want a copy. My original petition copy is missing.
How can this court give you a copy? You have a look at it. The matter is listed today. You have a look at it. Yes. Or ask the petitioner's counsel to give you a copy. As far as the court copy is concerned, you can have a look at it. Don't take it out from the court premises.
Well, I beg to mention item number 26 of today's part 1 list, my lord. In this matter, the petitioner has filed an IA, my lord, for withdrawal of the case, my lord. That IA has not been listed. It can be called for, my lord.
All right, you give the number.
Yes, I'll give the.
Call for.
Yes.
Yes.
My lord, I'd like to mention item number 4, your lordship. 414. Only 4, your lordship. Very sorry, your lordship. I have some personal difficulty, lordship, today.
Criminal petition 366376D. You are for?
Petitioner, your lordship. I have taken consent of other side also, your lordship. And can it be, lordship?
Friday.
No, lordship, in this one, since fasting is going on, lordship, some difficulties there. Can it be
When
on
do you want it?
April in any date, your lordship?
In item 4, Rupak?
4.
April or date.
After vacation, lordship.
As prayed by Mr.
Ice Borbuya.
I.H. Borbhuya, learned counsel for the petitioner, which is not, with consent from the other side, relist on such and such date. Yes.
Oblige.
May I please, your lordship? I beg to mention item number 22, lordship. On behalf of Mr. A.M. Bora, what had happened, lordship, we had filed it for the quashing of the FIR. A stay was granted, but recently we got to know the charge sheet has been filed. So we needed some instruction with the client of whether we pursue the charge sheet or we'll go with
You
the
are
FIR.
Mr.
V.A. Chaudhary, lordship. On behalf of
Chaudhary, right?
Lordship. My name is not there, lordship.
Mr. P.
V.A. Chaudhary.
B.
Lordship. V for victory. lordship.
V.A.
V.A. lordship.
Mr. V.A. Chaudhary, learned counsel for the petitioner, submits that during the pendency of the criminal petition,
Lordship.
the charge sheet has been
Filed. lordship.
filed
Okay.
and accordingly seeks accommodation to bring to obtain instruction
Lordship.
as regards the development.
Lordship.
As regards the said development. You have taken consent from
Lordship, yes, from the respondent.
prayer is not opposed. Relist on when do you want it?
Can it be in the month of April, lordship?
On such and such date. Yes.
8th April, lordship. Deeply obliged.
May I please, your lordship? Lordship, I beg to mention item number 16, lordship. Lordship, the youngest counsel is out of station.
You have already circulated adjournment slip.
Yes, lordship.
Mr.
A. Brahmo, lordship.
Mr. A.
A. Brahmo, lordship.
Brahma.
Brahmo.
Mr. A. Brahma, learned counsel for the petitioner by
16.
circulating adjournment slip in advance has praised for accommodation in the matter on the ground that the conducting counsel is out of station.
Yes, lordship.
Prayer is not opposed. Relist.
Lordship, any date may be fixed in the next week, lordship.
Yes. Relist Friday.
Okay. Much obliged.
Yes.
May I please, your lordship? Lordship, I would to mention item number 18 and 19, lordship. Lordship,
Yes.
both these petitions, lordship, have become infructuous, lordship.
Infraction.
Yes, lordship.
In item 8, who is for the other side?
More-
Item 18 and 19. Okay, they are connected, no? Connected, Mr. Ahmed?
Connected matter, Lordship.
Mr. Ahmed, learned counsel for the petitioner, before that, heard Mr. M. Ahmed, learned counsel for the petitioner. Stop. Also heard Mr.
AK Das on behalf of M Khan.
A.K. Das on behalf
Of
of
M.
Mr. M. Khan, learned counsel appearing for the respondent number.
Respondent Lordship.
Number who?
No.
Only single
Lordship.
respondent.
Hi.
Respondent number 5. And the others? PP.
Yes, Lordship.
And Mr. P. Thakur, learned APP for the state respondents. Mr. M. Ahmed, learned counsel for the petitioner, submits that in the meantime, the revision petition has become infractious and accordingly seeks closure of the revision petition. In view of the aforesaid endorsement made by the learned counsel for the petitioner, nothing survives for adjudication in the instant revision petitions, and as such, the petition stands dismissed on being infractious.
Revision petition as well as writ petition, Lordship.
As well as
The writ petition, Lordship.
one is writ, item 19 is writ petition. So you can give a separate order also if you want, then use the word writ petition. Okay.
Highly obliged.
Or if you give it combined, then you have to modify that. Any interim orders?
Yes, Lordship. Interim order was there, Lordship.
Interim order, if any, accordingly stands
Yes,
vacated.
Lordship.
Highly obliged.
There is one miscase. What is that miscase? Miscase is
Lordship.
Miscase 58, 2013. Is it still pending? Huh? 1819 or duta miscase আছে এটা রিটৰ লগত আছে এটা revision petitioner লগত আছে
Both the miscellaneous applications may also be closed, Lordship. Everything has become infracted.
What are the miscases for? Way of further proceedings. Still pending. The other one, criminal MC 58, like, accordingly, you make that order in view of that. This also becomes dismissed on being infraction. Both. There is another miscase 190 of 13. Both miscases. Okay.
Highly obliged.
You can make a one order also if it's convenient.
May I please, Lordship?
Separate 4 orders.
May I please,
Yes,
Lordship?
please.
Lordship, I beg to mention item number 20, Lordship.
20.
Yes, Lordship.
Yes, what do you want?
In this matter, Lordship, on last occasion, this honorable could direct us to obtain the instruction whether the property which is under question is right now under which possession, Lordship. We have trying to obtain the instruction but not yet get, Lordship. So I am preparing for a sort of
Mr.
MM Daman, Lordship.
Have you taken consent from the other side?
Lordship, I will inform, Lordship.
No. You don't make a mention and inform. The protocol is that you first inform, take their consent,
Actually,
and then mention. Otherwise, you wait. This court will accommodate you.
Lordship.
Do not try and change the protocols of these
Lordship,
court. Okay?
Lordship.
Because we don't know, they might object. How can this court allow you
Lordship.
time without their consent being on record?
Actually, we are trying to call him, Lordship, over phone.
So let you
I will
wait
wait,
for
Lordship.
the item to be
I-
called.
I
Any
will-
difficulty?
I will wait for, Lordship.
You wait. Please call the list. Yes, Mr. Mukit, where is your counterpart?
That's the thing, my lord.
16 matter. What is this criminal petition?
For quashing, my lord, first is the criminal petition 81 was filed earlier. That is item number 2. That was for quashing of the FIR.
Okay.
And then we filed the affidavit there, my
Uh,
lord, where we stated that charge sheet has already been filed.
Then the
Then
second
they
is for filing the for quashing the charge sheet as well.
There, I have not been supplied the copy, or the notice has not gone to me.
In item, but you already have it. Where is the FIR? Where is the FIR?
My lord.
You don't have item number 1.
Item number 1, I don't. Item number 1, I don't.
Mr. Bhattakur, you have a file.
There was cases pending since long.
No, that is why I wanted to see if there is anything, if there is, if the FIR, if allegations are made out in the face
It
of
is
the
made out,
FIR charge sheet on
It
the
is made
materials. Huh?
It is made out.
Then why should we keep this matter
Exactly,
pending? We can,
exactly.
just because the petitioner council have not appeared, doesn't stop this court from going into it.
Absolutely, my lord.
That's why, but you are not assisting me now.
My lord,
Where is,
I am not armed with the copy, my lord. That's
no,
item number 1.
because even here it appears only, I think only the charge sheet has been annexed as annexure A. I don't see the FIR. Give me the other,
If you-
other
if your lordship
number
would,
2. You have item 2 filed.
My lord,
You have the item number 2
my
filed.
lord, my lord. There also, my lord,
Where is the FIR in that?
FIR, the
It-
handwritten
I'm
FIR
looking
is
at
given, my lord,
Lecture
page
of a
number
charge sheet,
12.
okay, too. Mr. Bhattakur, is that the charge sheet? Just check. I think only the charge sheet has been annexed. Yes, yes, FIR,
At page 12, my lord.
page 12.
In the charge sheet. is-
Just mark the operating part from the charge sheet. Okay, Mr. Bhattakur? Yes, I am at page 12. It starts at 15 now. 10, 11, 12. Yes, 12.
12, my lord. They have not supplied the translated copies, my lord.
Translated copy is not there.
FIR. Charge sheet আছে, FIR. My lord,
Page 14.
my lord, page 14 is the anticipatory bail order.
Oh. How come this?
How come, my lord, this was
How, yes,
allowed, my
how
lord?
we have,
Exactly, my lord.
sorry?
It's not more reserved for জমি করা উত্তর কাহিনী কোয়াট দাদাই মোর আৰু এজন গাড়ী লৈ আহি মোৰ নোটিছ লৈ
There is a stay operating?
No, my lord, initial order does not, in item number 2, my lord, I can say, there is no such. One order was there that, in item number 2 dated 4/2/2015. While issuing notice upon me, my lord, it was,
This is not a case which can be,
my lord.
but should I dismiss it on merit or? Okay, they have not appeared. Any idea what is happening at the
My lord, I don't have,
investigation?
I don't have any instruction.
Regarding the medical report, but those reports are also had on the report statement.
None appears for the petitioner. Mr. Jed Mukit, Learned Counsel, heard so and so.
I'm for the
Learned
informant.
Counsel for the respondent number 2 stroke informant, and Mr. P. Bhattakur, Learned APP for the state respondent. In view of the non-appearance of the petitioner, non-appearance of the Learned Counsel for the petitioner, for the petition stands dismissed for non-prosecution.
All right.
May I please, Your Lordship, I am for the respondent, my lord. They are on interim since to 23/5/16, my lord.
What is this? What are the charges?
It was
468, 471.
471, yes, my lord.
There is an interim order operating.
Yes, my lord, since 23/5/16.
Where is the FIR?
I don't have the brief, my lord, actually.
Huh?
I don't have the brief, my lord.
Why? Why you don't have the brief?
It's a old case, my lord, I did not find, my lord.
You could have checked the court file.
Yes,
You
yes,
could have
I have
come half an hour in advance and.
I have
please,
checked, my lord, I have checked.
FIR, you should have the relevant
Right. Sir.
in a small piece of paper, you could have jot down, this is how we used to do
Yes,
if
madam.
the files are not there.
Yes.
What is expected from you is the assistance, right?
My lord,
If we don't get it from the bar, how do we proceed?
my lord. Lordship can fix this matter for hearing, my lord.
Fixing, there is no difficulty.
Yes,
Let's
ma'am.
see if there is anything. He's enjoying a stay.
Yes, my lord,
It's a complaint case.
Yes, complaint case, my lord.
Uh, None appears for the petitioner on call. Mr.
D. Bora, my.
Heard Mr. T. Bora.
Yes, D. Bora, my.
D. Bora, learned counsel appearing for the sole respondent.
Yes, my lord, sole
For
respondent.
the sole respondent. Stop. It appears that the interim order, no, the interim order was not continued. It appears that interim order passed earlier was directed to be continued till 16/6/2020 by this court by order dated 28/5/2020. In view of the fact that there was no representation on behalf of the petitioner on call, though the names of the 5 counsels reflected in the cause list have been called out. No, despite names of 5 counsels being reflected in the cause list. Stop. It appears that on 16/6/2020, on the prayer made by on behalf of the petitioner, the petition was directed to be listed after a week. Stop. Pertinent that on 16/6/2020, interim order passed earlier, which was directed to remain in force till 16/6/2020, was not continued thereafter. It further appears that thereafter the matter was listed on 11/12/2020, on which date also on behalf of the petitioner, the matter was the matter stood adjourned. So after 11/12/2020, the matter has come up to today. Today, on which date also there is no representation. Don't say also, there is no representation on behalf of the petitioner. Relist on Wednesday in the order column with the remark for dismissal.
Obvious, ma'am. Deeply obvious.
Today also, you said, today you said no, they are not appearing. There also you said, despite the names of the 5 councils being reflected in the cause list. Yes,
My lord, this criminal petition is filed. My lord, challenging the proceeding, my lord, under section 420 and 406, my lord. The
yes.
ground,
It's a
the ground-
complaint case or FIR?
complaint was lodged, my lord, and which is forwarded to the PS and FIR registered under section 420 and 406.
Where do we get the complaint?
Yes, my lord, page number 13, the complaint.
What is this judgment that you are seeking to be quashed?
My lord, actually the order was passed, challenged in discharge stage. The discharge petition was dismissed. That was challenged before the session court.
Where is that order?
Yes, my lord. First order, my lord. Page number 22 is the first order before the trial court. My lord.
This is the first order.
Yes, my lord. Next, second order, page number 26, my lord. The judgment, my lord.
Revision.
Yes, my lord.
You are for the?
I am the my lord, accused. The petitioners are father and son. My lord.
But how can these grounds be taken that the trial court did not appreciate the materials on record in its true and proper perspective? Where is the scope of the trial court at the discharge stage to appreciate and reappreciate the evidence? The test is to take the materials collected by the prosecution on its face value and see if a trial is put and whether a conviction is likely or not. That is the duty. But the correctness of the allegations and the materials cannot be appreciated and reappreciated. Your ground is that in para 1 it says on the following grounds. Read para 3.
My lord, my petition, my lord. Corrective judgment, my lord.
Text 27.
Yes,
You are for the complainant?
My lord,
Yes.
respondent, in this petition respondent.
my lord, the brief fact of the case is that the opposite party of this division petition being complainant filed a complaint before the learned CJM Hailakandi, whereby it alleged that petitioner and the opposite parties are inhabitants of the same area. On 14/1/15, the revisionist went to the house of the opposite party, that is the complainant, and stated to the complainant that if he purchase a truck, my lord, at this stage, my lord, I will, my lord, press or I will submit on the prima facie whether it is a civil nature case, my lord.
You
So,
read.
my lord, this is the complaint, my lord. He purchased a truck from Tata showroom at Guwahati, and his son, being the revisionist Muazzam Hussain Lashkar, would get a job in the said showroom, and his another son, Dilwar, would drive the vehicle. Initially, the opposite party complainant refused the said proposal. Thereafter, the revisionist went to the house of the friend of the complainant and convinced him to purchase a vehicle jointly with the complainant. Thereafter, the complainant paid an amount of rupees 1,50,000 and the said friend of complainant also paid a rupees 1,50,000 to the accused revisionist in presence of witnesses. The revisionist Muazzam Hussain Lashkar, along with witnesses on 15/1/15 went to Guwahati to purchase the truck. After 1 day of them being reached in Guwahati, the revisionist Muazzam Hussain Lashkar informed him over telephone to deposit an additional amount of 1 lakh in his bank account, and accordingly he deposited an amount of 75,000 on 19/1/15. Thereafter, again the accused Muazzam Hussain Lashkar informed them deposit 2 lakh, and accordingly they deposited the said amount on 16/2/15, 17/2/15, 18/2/15. Thereafter, the accused Muazzam Hussain Lashkar told the person who were with him in Guwahati that he deposited the entire amount in the account of Tata showroom, and he was instructed to go back home, and after 1 month he would come again to receive the vehicle. Accordingly, all of them returned to Hailakandi after 25 days. Anwarul and another went to Guwahati and
I don't find anything wrong, Mr. Counsel. There, you see, your case is not, of course, it could be pure, civil also, but it cannot be purely civil. Your case is both civil and criminal. Both proceedings can go on simultaneously against you. Because the inducement appears to be there at the initial stage, the fraudulent intention, everything appears to be there. There are allegations. You see, I don't know whether these allegations tomorrow will be proved, not proved. We don't know that.
Yes, at
But
this stage.
correct. But at this stage, because I have a very limited scope,
Yes,
isn't
yes,
it?
Yes, ma'am.
And it appears that the revisional court has very correctly has looked into the facts and have held that there is no legal infirmity in the order of the trial court dismissing the discharge application.
Yes.
Nothing. There is no error here.
So, my lord, the complaint is, my lord, prima facie, my lord, a vague complaint, my lord. A vague complaint, my lord. There is no, my lord,
A bad complaint.
vague complaint, because, my lord,
Sorry, what complaint? What complaint?
it is a vague, my lord.
Vague.
Vague, my lord, because,
Well, what do you mean by vague?
my lord, because, my lord,
Where are these, all this which appears?
yes,
has
transaction is
come
there,
out?
my lord. Transaction is there. It is,
Then
transaction is there, my lord.
it's vague.
But, my lord, this,
Inducement.
yes,
There is
my
an
lord,
allegation that you went and you asked him that gift.
that is, my lord, right.
And because he said he will not give, you went to his friend.
That is-
And then you convince his friend to come with you, and accordingly both of them, since now his friend has been involved,
That-
he gave it.
that is, my lord, allegation and proof is there.
Mr. Counsel,
Yes.
can this court look into the correctness of these allegations? Am I convicting you?
No.
Then
It
it is for the trial court.
Trial, my
So when these allegations are there, which you are also saying, yes, allegations are there,
allegation there, my lord.
then,
But, my
then
lord,
how can the trial court discharge you?
my lord, the proof of transaction is there, my lord. But there is,
Allegation is there.
nothing.
All right, where is the FIR?
Well, FIR is page number 13, and it starts from 15, my lord. 13, my lord, and the
Yes.
relevant part is page number 15. my lord.
Yes.
May I read the complaint?
Yes, please.
Page number 15, paragraph number 7, facts of the case. That the complainant as well as the accused persons are inhabitants of adjoining villages and they are related to each other. On 14/1/15, the accused 1 and 2 went to the house of complainant. 1 and 2 is the father and the son, the petitioner's hearing. The accused number 2 said that his son, accused number 2 is the father, son, accused number 1 resides
Convinced him to purchase.
at Guwahati. He also said that if I purchase a 709 truck from Tata showroom from
And
Guwahati,
then you disappeared. Sorry, I am going fast, but I have read it.
yes, my lord, it is an unbelievable story, my lord.
That is where
that
the
one of the
problem
petitioner-
comes, Mr. Counsel. How can this court disbelieve these allegations at this stage? Or how could have the trial court ignored these allegation at the stage of framing, at the stage of charge framing?
Yes.
How? How? You tell me. How can it be ignored?
My lord,
If the trial could have ignored this, she would have come running before the revision court to they're saying that the trial court has unsettled the settled position of law. And therefore it is absolutely palpably erroneous. Correct?
my lord, the
Okay,
amount, the
sorry.
transaction of money, my lord.
I'm
Transaction of-
sorry. The transaction of money, whether has happened, not happened, this court cannot go into it now.
My lord, the unbelievable story is that, my lord, he will purchase a truck, my lord, and my prayer is that in his truck, my son will be driver, and that my son will get an employment. And on the basis of that, my lord, he will purchase a truck, my
Sorry,
lord.
sorry.
That is an unbelievable story, my
Sorry.
lord. And my lord, what is the transaction is there, my lord? It is he can go for a civil suit, my
You
lord.
see, at the time of framing charge,
Yes.
the court will see all this. Now, initially it was filed an FIR or complaint,
Complaint, my lord.
and that
complaint.
complaint was subsequently
Complaint
registered
registered
as
as
an FIR.
FIR.
Yes, yes, you want to say something?
No, my lord. My lord, petitioner number one never submitted any bank statement or whole period, my lord. If they show, my lord, your lordship will be pass any order, my lord.
Otherwise, at this stage, my lord, this petition has been filed, my lord, against order of framing charge. So after, my lord, at this stage, my lord, court is not required to go to the probative value of these, my lord,
Correct.
of the, my lord, materials available on record. And from the materials now available before the trial court, on the basis of that, my lord, charge has been framed against the petitioner.
All right.
So, my lord, there is no legal, my lord, insanity in the order.
Proceedings are stayed.
State, my lord.
Which order?
Very fast order. 27/7/18.
All right. Please
My
take
lord,
down.
may I place, my lord,
Yes,
two-
yes.
two decisions, my lord,
Yes, yes.
my lord, regarding this civil
Yes,
matter case,
please.
my lord.
Borwa?
My lord, this is 2019-11 SCC 706 Anand Kumar Mohanto and another.
Yes, paragraph
Paragraph, my lord, married 24-25, my lord.
24.
25, my lord. 25, my lord, married, my lord. Regarding civil nature, my lord, which do not involve a criminal offense.
In this case, the apex court has quashed the FIR because the apex court was of the opinion that the present case falls under first, third, and fifth category of Bhajan Lal, of the principal surround Bhajan Lal. In
Yes.
such a situation, powers can be exercised, and those first, third, and fifth. First is where the allegations made in the FIR or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute.
Yes.
This is against you because the allegation, even if it is taken on the face value, without going into the correctness,
Yes.
offense is made out. Then number three, third category, where the uncontroverted allegations made in the FIR or complaint, and the evidence collected in support of the said do not disclose the commission of any offense. Here, the materials, the FIR, the uncontroverted facts contained in the FIR complainant and the materials apparently prima facie makes out a case against you. So that is also not there. Now fifth, where the allegation made in the FIR or complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. This is the discretion of the court.
Yes, so my submission was
This
that,
is
my
the
lord.
discretion of the court.
Yes, yes.
Now, how will the court arrive to this conclusion? That by looking into the averments,
Yes.
the court has already seen the averment.
Yes.
The court is convinced that the averments, if is taken to be true, makes out a case. There is nothing in the complaint or the materials collected by the prosecution which may give a doubt in the mind of the court that these allegations could have been manufactured. There is nothing. And even if a doubt comes, merely because a doubt is there, the court is not going to, unless and of course, no reasonable man by seeing the FIR could think, no, this is absolutely false. You are trying to build your case on the ground that because the ground for taking money is that his son wants a job.
Yes, yes. my lord.
Now, what is
My-
improbable about this? We all know that when somebody in the in the distributor company, if they sell a vehicle, they get a job. Maybe he was doing internship, or maybe because through him a car is bought, he could have given a job. We don't know all this. Evidence will come, evidence will tell.
Yes.
How can we say this allegation is improbable? This decision doesn't apply to you. And you see, the decision which was relied here, 1977, the Karnataka decision.
Yes.
There also, if you see in para 28, the apex could have said,
Yes.
we find that the prosecution is mala fide, untenable, and solely intended to harass the appellants.
Yes.
This was the decision,
Yes,
which is relied in this decision, Anand Kumar.
Yes.
Now, where are the materials here which indicates? Sorry. Yes, next
My lord,
case.
Guwahati High Court one judgment, my lord. This is.
See,
2072
cases are
and-
contextual. So if you want to rely a case, it should apply to the facts of your case.
Yes. My
Merely by relying one sentence of one judgment is not
Yes.
going to improve your case. You have to show to this court how that decision, the facts of that decision fits into your case.
yes.
Your case, I have indicated, the facts are absolutely clear, the allegations.
Yes.
There is no doubt in the mind of this court
Yes.
that those allegations prima facie doesn't make out a case. It does.
My lord, the second case was that, my lord, Kishore Das, that initial, if there is a transaction, that was not, my lord, initial, there is not a dishonest intention, paragraph
You
12,
see, Mr. Counsel,
paragraph 12.
in your FIR, it is clearly said that he induced, he went,
Allegation.
but he refused.
Yes,
He went and convinced his friend.
yes,
How can you say that at that time, the dishonest intention is not there? It is apparent. And then he disappeared after taking all the money.
these are allegations, my lord.
Repeating your arguments will not take you anywhere,
Definitely.
Mr. Counsel.
Definitely.
You are an officer of the court.
Yes.
Sometimes you must show that fairness
Yes.
to the court also.
Yes, my lord. My,
Repeating arguments will not help. You see, if a given case,
yes,
since if you've been in court, you would see that when there is no case, I am quashing the FIR. But if the allegations are like this, how can you expect a court not to frame a charge? How can the court look into the probability value of the allegations?
otherwise my submission was that, my lord, it is civil nature case, my lord. That was my submission.
Civil nature, you're right. But in the facts of this case, both civil and criminal,
Allegation.
both. There is no law saying that even if there in a given case, if
Yeah.
civil and criminal
Yes,
both,
sir.
just because there is civil, therefore you have to go before the civil court.
Criminal.
You have to make
Criminal.
out a case of a purely civil in nature. Cases could be purely civil in nature, could be purely criminal in nature, and could be both civil and criminal. In the third category, you have the options of proceeding before both the forums simultaneously.
Obliged.
So here, if they have not gone into civil, then that is your good luck, but they are entitled to take you before the civil court as well for recovery.
Obliged.
Yes, please write down. You are Mr. M.J. Kadir?
Yes.
Heard Mr. M.J. Kadir, learned counsel for the petitioner. Stop. Also heard M.S.
L Wajida, my lord.
L.
Wajida,
Sorry,
L Wajida.
Wadina. Learned counsel appearing for respondent number 2 and 3.
My lord.
2 and 3.
Respondent number 2, my lord.
Respondent number 2. And Mr. P. Borthakur, learned APP for the state for the state respondent. Stop. By this application under section 482 of CRPC 1973, the petitioner is seeking quashing of the judgment and order dated 6/7/2018, passed by the learned session judge Hailakandi in criminal revision number 86/2017, comma, the impugned order dated 25/10/2017, passed by the Judicial Magistrate First Class Hailakandi in GR case number 1592 of 2015, arising out of Katli Chaira Police Station case number 123 of 2015, registered under charge under section 420/406 of IPC, and the charge sheet dated 31/10/2016, filed in connection with GR case number 1592/2015, registered under section 420/406 of IPC. On top, you say inter alia. Huh? The brief facts of the case is that on 29/7/2015, the respondent number 2 filed a complaint being CR case number 780 of 2015 before the Court of Chief Judicial Magistrate Hailakandi. You may say now Magistrate Court. On top, you say Magistrate Court and Revisional Court. The first order is by the Revisional Court hereinafter, and the second one is hereinafter Magistrate Court. मतलब इसी भी कॉमेडी बनेगी दूटा सलाह से नहीं. Alleging inter alia that on 14/1/2015, the petitioners went to his house and told him that if he purchased a 709 Tata truck from Tata showroom from Guwahati, then petitioner number 1 would get a job in the showroom and his brother would drive the vehicle. Though the opposite party number, though the respondent number 2 it is further alleged that though the respondent number 2 initially refused to accept the request, but later on, at the behest of since the petitioner convinced his friend Amir Uddin Barbhuia to jointly purchase the vehicle in question, comma, he therefore paid rupees 3 lakhs to the petitioners and subsequently deposited an amount of 4,85,000 in the bank account of the petitioner number 1. Accordingly, a total amount of rupees 7,85,000 was given to the petitioner number 1, but he neither purchased the truck nor returned the money. It is further alleged that thereafter the petitioner disappeared. Stop. Next part. Thereafter, the magistrate court forwarded the CR case to the officer in charge, jurisdictional police station, with the direction to register a case. Stop. Accordingly, an FIR was registered, being Katlichera PS case number 123 of 2015 under section 420, 406 IPC. FIR was registered on 4/8/2015. On 4/8/2015. After completion of investigation, you may change the para. The investigating officer submitted charge sheet on 31/10/2016 against the petitioners under section 420, 406 of IPC. Upon submission of charge sheet, the petitioners appeared, no, the petitioner filed a petition, white petition number 259/2017 before the magistrate court on the date fixed for appearance, seeking discharge from the case. The magistrate court, by order dated 25/10/2017, was pleased to reject the said petition and framed charges under section 420, 406, 34 of IPC against the petitioners. Stop. Being aggrieved, the petitioners filed a criminal revision petition before the being CR criminal revision number 86 of 2017 before the revisional court. Stop. However, the said revision petition was also dismissed by the revision court by order dated 6/7/2018. Situated thus, the present criminal petition has been filed for setting aside and quashing the aforesaid orders of the magistrate court as well as the revisional court. Mr. Kadir, learned counsel for the petitioner, submits that the allegations contained in the complaint is highly improbable, and therefore this court, by exercising the powers of section 482 CRPC in terms of the principle number 5 propounded by the apex court in the decision, in the case of State of Haryana versus Bhajanlal, reported in 1992, supplementary 1 SSC 335 B, quash the impugn orders of rejecting the discharge, impugn orders of the magistrate court as well as the revisional court. Stop. In support of the aforesaid, he relies upon the decision of the apex court in the case of Anand Kumar Mohata and others versus state within bracket government of NCT of Delhi, Department of Home and another, reported in (2019) volume 11 SSC at page 706. Per contra, MS so-and-so learned counsel for the informant submits that the allegations set out in the complaint petition and the materials collected by the investigating officer, materials collected by the prosecution are sufficient enough for framing the charges in question. Next paragraph. Mr. P. Thakur, APP, for the state respondent, submits that the argument of the learned counsel appearing for the petitioner as regards the probative value of the allegations set out in the complaint cannot be looked into by the magistrate court at the time of framing charge. He accordingly submits that there is no infirmity committed by either the revisional court or the magistrate court whereby the charges under section 406, charges under section
420 and 406.
420, 406 of and 34 of IPC was framed against the petitioners. Stop. Heard, perused, considered.
One submission of civil nature, my submission.
Sorry. Where you have said Kadir, no? There you also say after that citation, okay? He further submits that the allegation made out in the complaint is essentially of civil in nature, and therefore the continuation and therefore the order of the magistrate court framing charge under section 420, 406 of IPC against the petitioner is totally erroneous, and accordingly the order of the revisional court upholding the order of the magistrate court is palpably and manifestly erroneous. Correct?
Okay.
Then apt at the outset to reproduce the relevant paragraph of the complaint, which is reproduced here under already referenced, quote unquote, page 15 to page page 16. Reading of the aforesaid averment set out in the complaint, it appears that the petitioner approached the complainant requesting a loan in connection to purchasing a vehicle in the name of his son, so as to ensure that the son gets a job in the distributor in the office of the distributor of the vehicle in question. It further appears that the complainant refused to give the said loan to the petitioner. It appears that thereafter the petitioner went to the house of a friend of the complainant and convinced him to purchase the vehicle in question jointly with him. It further appears that since the friend of the complainant joined with the petitioner for purchasing the vehicle in question, comma, the respondent number 2 gave the subject loan to the petitioner. It further appears that thereafter neither the petitioner purchased the vehicle in question nor returned the said loan given by the petitioner. It further appears that the petitioner,
May I submit one thing, Madam?
it further appears that after receiving the loan amount, the petitioner number 1 disappeared and could not be found at Guwahati. Stop. It further appears that after completion of the investigation, it further appears that after the instant complaint being registered as an FIR case as per the order of the magistrate court, the investigation was completed by the investigating officer and a charge sheet was filed against the petitioners under section
420 and 406.
420 and 406. It further appears that on the date of appearance fixed for it, on the date of appearance of the petitioners fixed by the magistrate court, comma, the petitioners on that date filed an application seeking for discharge which the magistrate court was pleased to reject and frame charge against the petitioner under section 420, 406, 34 of IPC. Apt to refer to the order dated so and so of the magistrate court, which is reproduced hereunder for ready reference. A2A court, page 22. It appears that thereafter that a revision petition was filed against the aforesaid order of the magistrate court, which was also dismissed by the revisional court. Apt to refer to the relevant paragraphs of the judgment and order of the revisional court, which is reproduced hereunder for ready reference. Paragraph 8, 9, 10. Quote unquote, page 28. Okay, A to A. Reading of the aforesaid order of the revisional court, it is apparent that the revisional court, after perusing the complaint, was satisfied that the petitioners induced the complainant to pay money on the pretext of purchasing a truck, and when the money was paid, the petitioner disappeared. comma, was of the view that prima facie materials to proceed against the petitioners attracting the alleged offense with which they are charged is made out. This court is also of the opinion that the ingredients of section 420-406 as regards initial fraudulent intention and fraudulent misappropriation is clearly made out in the body of the complaint. That being so, this court finds no infirmity in the order of the judgment and order of the revisional court. Stop. Be it pertinent to be mentioned herein that the argument of the learned counsel for the petitioner that the allegations made out in the complaint is purely civil in nature is rejected, inasmuch as allegations set out in the FIR stroke complainant may be can be purely civil or purely criminal or partly criminal and partly civil. In the first category, no criminal offense can be said to be constituted. However, in the second category, criminal offense is made out. And in the third category, both civil and criminal proceedings can be simultaneously proceeded against the petitioner. Stop. In the present case, the ingredients of section 406 and 420 being made out in the body of the complaint, comma, this case falls under the third category, i.e. partly civil and partly criminal. Stop. Though learned counsel for the petitioner, by relying the decision of the apex court in Anand Kumar Mohata, Supra, made an attempt to bring his case under the category of highly improbable and absurd, on the category that the allegations made in the FIR stroke complainant are absurd and and inherently improbable, comma, this court finds nothing improbable in the allegation made in the complaint. In fact, at the stage of framing charge, this court cannot look into the probative value of the allegations made out. That being so, the instant criminal petition fails. The judgment and order of the revision court stands upheld. Dismissed.
One thing in the regarding facts, my lord, it was not a loan amount, my lord. It mentioned a loan amount. In the page number 55.
What would it mean?
And it mentioned that the truck will be purchased in his name, in the complainant's name.
Okay, but then instead of the loan,
loan.
you say amount. Just use the word amount. Okay.
Ajab, like.
number 6 to 9.
May I please, your lordship? Hello, on the, if your lordship will peruse the last order, my lord, it clearly says that my lord diary was sought for by the prosecution and to prepare the case, my lord. So whether the case diary has come or not, first it needs to be clarified, my lord. I said,
Otherwise, my case diary is not received.
the question is it?
Case diary not yet received, my lord. Otherwise, my lord, matter is of
18.
18 and interim
Which
stay
is the
granted.
order, Mr. Seeking for the case diary, which is that order?
Last order, my lord.
In which case?
My lord, in item 6 probably, my lord.
The first case is common order.
I'm
I'm
giving, my
not
lord.
finding it here.
Yeah, no. It's order dated 27/2/25 passed in. my
27?
lord, yeah, 27/2/25.
That's it.
Passed
Is it
in
And the IA.
IA criminal 830, my lord.
It's not available.
CD not available.
It appears that
Interim-
this
interim-
order dated 27/2/2025 directed the I think there's another order by which it was called, because here they were seeking allowed the, not directed, allowed the
The prayer.
prayer of the additional public prosecutor for adjournment in order to facilitate him to go through the records and the case diary and also
To produce the case.
and also the case diary which was not received till then, and also the case diary which was not received on the last date of listing. Stop. It appears that Mr. Borthakur so and so. No, don't say it appears. Mr. Borthakur so and so, APP so and so, submits that you have gone through the records.
My lord, yes, I have not gone through the detailed records, my lord. But my lord,
Submit that he could not go through the detailed records, and further the case diary is still not available.
otherwise, my lord, in this case, interim granted on 27/7/2018, my lord. That my lord, FIR laws in the year 2017. So then thereafter, my lord, immediately thereafter, matter has been stayed, my lord. And my lord,
I think it was lawfully stayed by the High Court.
yes.
No issue for that.
Yes.
I think what he's trying to say that
Yeah,
maybe the case
that's what
diary,
Yes.
nothing much will be there in the case
Yeah,
diary.
I have got no issue, my lord.
Are you trying to
That's
say
what it
that?
should directly say,
He's
my lord.
trying
He
to
is
say
going,
that.
Yes.
he is going in a
What-
delivery
Okay, my
way.
lord, I will get it, my lord. I will get it.
What
You
is
get
the
it,
problem
we'll do
in
it.
getting it?
Yes, my lord, I will get it.
That is
Get
a straightforward prayer, my lord.
Let's be fair. There is an order and
Yes.
senior counsel is asking, get it.
Yes, my lord, I will get it.
Straightway make submission, right?
How much time will you take? Where is it going to come from?
From Guwahati, my lord.
Guwahati, my lord, on today.
Next Monday?
Yes, my
My
lord,
lord, let it be.
not Monday, my lord.
My
on-
lord, let it be after view, my lord.
Mr. Kaman, it's an 18 matter.
No, we are there, my lord, but we have Eid after
It's an
that.
18 matter.
Then 27th, my lord.
27?
27.
Not of each month, my lord, let it be after Eid, my lord. That is that much.
Okay.
My lord, any date, my lord.
Then 3rd of April.
Third or third or episode did you? 10th April.
My lord, that will do.
Accordingly, let the case diary be called for and placed before this court on the next date of listing.
Sure.
It is needless to be clarified that that the additional PP shall go through the records and be prepared with the case diary on the next date of listing.
Sure, my lord. Just pointing it out, this item was heard twice.
relist,
by different
relist.
courts.
My lord, but problem is that earlier, my lord, although matter is pending since long, matter is kept on, but CD was called for later on, my lord. That later state that.
Later on, call for at the
But
prayer
now
of
you have
yours.
it. You see,
not court
I'm
has-
putting this so
yes,
that
yes.
you can
Yes,
also
yes.
put pressure and
Yes.
get the CD. Let's not keep this matter hanging.
Yes.
There's an interim operating.
Yes.
Because PP prayed on the last day. to-
Relist
that he
on
will,
such
produce the case diary.
date, huh?
March of February.
Interim already for, it's already continuing or anything to be mentioned for the.
No, no, madam, that's good enough. March of February.
Well, appears for the petition, all of this one, is that material. So,
Item number, hearing, first, first
yes,
item? Yes, basic MS P Chakravarti is for the petitioner. She informed me in the morning that there is a strike, so there won't be court. Might be she did not know that court said.
what is this? What kind of a lame excuse, Miss Counsel?
No, I'm not,
No, why she should take that kind of an excuse and not come to court? I'm not telling you.
Yes. No, because
a-
I cannot,
It's a
because
2012 matter.
might be she had some misinformation also that court.
No, whatever information, the strike means that the court will not sit. Does that mean? How can it be taken?
Lord,
How
but-
can she please convey the message of the court to her? Because this is not correct. How can you assume that the court will not sit or the court will not take up the matters? Especially hearing matters of 2012. And I'm told the strike is at 11. It's not even 11 now. She didn't have the decency enough to come before the court and make a mention.
Actually, I called her.
You please tell her.
No, Lordship, what happened?
You see, you took it up on you to
No, I
tell
did
this
not, I
court.
did not.
So you please inform
No,
her.
No, Lordship, it will be
No,
wrong.
what I am not telling you.
Yes.
Please
Actually,
understand.
I called her up. I did not know about the strike. I said, are you ready with the matter? Because last occasion also they were not ready. So, because I have to be also ready. She told me, no, there was a strike. So nobody is going because we are asked not to go.
Very sad state of affairs. And item number 10 and
Might
11.
be she was misinformed.
Relist, Tuesday, Kali Tuesday, na? Relist Wednesday, did you? None appears for the petitioner on call. MS S. Ahmed.
Parveen.
MS
Parveen.
SP Hussain.
SP Hussain.
MS SP Hussain, Learned Counsel for the respondent number. Sole respondent.
Sole respondent.
For the sole respondent submits that when she had called the
Lordship, may I pray? It should not be recorded. It will
no,
look
but
odd
this
on-
is what you are submitting.
No, if I don't.
You see, if you wouldn't have submitted this, I could have also dismissed
Because-
this revision petition for
Yes, yes,
default.
I did not want to do.
You have, that's why I've said you have taken it on yourself. Relist Wednesday, Didya. It
Wednesday
is
is what?
needless to be clarified that on the next date of listing, if the Learned Counsel, if the two names appearing for the Learned Counsel reflected in the cause list is not present, the matter shall be proceeded in accordance with law. Second time মাছি দিব।
My lord, in item number 12, my lord, may I take this paper book, my lord?
But I have not adjourned it.
My,
Please, your lordship, this matter may be kindly be passed over for a day.
Why?
Senior is on legs. Senior is on legs.
What is this revision petition, Mr. Lawcore?
I could not
Actually-
go through Rosif. I could not go through Rosif. I was in another court Rosif just now. I have found it.
The husband family has filed for coaching of order dated 1/9/12 passed by the Learned Munsif Court.
in CR case number so and so under section 498, Lordship.
Yes.
Actually, the informant petition was pressing the petition number 3 to stay in our father house at Golbara, and also assure to help financially to do business at Golbara, but petitioner number 3 did not agree without carrying the objection of our husband left for Golbara. So after that, she filed a CR case in Golbara, Lordship. Both of them were staying in Bongaigaon.
When? He's on legs. So I'll give it pass over
after
for the
some
time
time.
being, after some time. None appears for the petitioner on call at within bracket. Keta bajise etia? 11:45 PM. Relist Wednesday in the order column with a remark for dismissal. Yes.
Please, your lordship. My lord, this is a revision petition since pending 2012, my lord.
Yes.
My lord, at the very outset of our submission, with all respect, I will inform before your lordships that we have perused the case record, original case record. That is the appellate court as well as the magistrate court here, my lord. What happened, my lord? It is shown in the record that even after direction to surrender before the court, he did not surrender, and as a result, proclamation has been issued against him. That is the fact of the case, my lord.
You are challenging the orders whereby the proclamation was issued and the revisional court
Yes.
refused.
Against the order, my lord.
Against the order of issuing proclamation.
Yes, yes.
Mr. Counsel, you don't know the facts of your case.
Against the judgment, my lord.
Which judgment? What was done by that judgment?
Session judge, my lord.
What is happening, Mr. Counsel?
Magistrate court, my lord.
Hmm?
Magistrate was also directed to surrender before the
Magistrate was directed to surrender.
Yes.
Magistrate was directed to surrender. Yes, assisting counsels.
No, revisional court, no, my lord. Session judge in appeal directed to surrender before the trial court.
Directed whom?
Directed to the magistrate, my lord.
Directed the magistrate to surrender.
Accused petitioner.
Mr. Counsel, what is happening? You must be mindful that you are on legs before the High Court. You must be prepared with your facts. This is a matter of 2012. You yourself started with the submission that this matter is old and pending since 2012.
Yes,
and you are not even acquainted with the facts of the case.
Yes, my lord. My lord.
What kind of submissions are you making?
We are sorry, my lord. My lord, what happened?
It's not about being sorry. And what is this? You are now smiling.
My lord.
Please don't make a mockery of the court's proceedings.
This is the fact of the case, my lord.
Very strange. The assisting counsels are saying something to you. You are making some other submissions. They are repeatedly. From here we can see what is happening. They're trying to correct you.
Yes.
Yes, Mr. Bondhagur, what were you saying?
Otherwise, my lord, appellant is convicted by the trial court under section 357 and 380, my lord. Thereafter, my lord, the appellate court has, my lord, modified the sentence regarding section 380. Therefore, the sentence as imposed by the learned trial court to the accused appellant under section 380 of IPC is modified and sentenced the accused appellant Praveen Gandhia to undergo rigorous imprisonment of 2 years with fine of rupees 300.
in default of payment of fine as imposed under section 457 and 380 of the IPC. The accused appellant shall undergo with another shameful imprisonment of 10 days. Thereafter, my lord, it was also directed by the appellate court that, my lord, what my friend has trying to point out, accused appellant is directed to surrender before the learned trial court within 2 months to serve out the sentence. So as per his submission till now, the accused person after order passed by the learned appellate court, accused
did
person
not
has
surrender.
surrendered before the trial court.
And
Then
therefore,
regarding there is any
proclamation has
stay-
been issued.
Any stay of the suspension of the impugned order, my lord, thereafter, my lord, in this case, my lord, I have not gone through that, my lord.
But what is in this revision, what is being challenged is the order of the appellate court.
Yes, my lord.
Isn't it?
Yes,
In criminal appeal, dismissing the appeal and upholding the conviction.
yes,
That is under challenge.
yes.
So this court has to now, in the revision court, this is a revisional exercise. Yes, where is the order of the appellate court, 18/4/2012, page number? Yes, assisting counsels, page, tell me.
Page number 10, my lord.
10. Yes, read from page 11. Read.
From page 11.
Or you ask your assisting counsel to read it for you.
Page 11, my lord.
Yes, read. I have heard from PW1.
May I read, my lord?
Yes, please.
My lord, decision and reasons, my lord. I have heard the
Read from PW1.
PW1. PW1, my lord, Sri Nikhil Gondhia. Nikhil Gondhia, the informant, deposed that he was not present at the house which was locked. On his return, he saw the lock intact, and when he, along with his wife, entered into the house and saw the joining of the walls of the kitchen open and the back door open, his wife, after entering their room, found gold ornaments, utensils, and rupees 2,500 missing. PW1 deposed that these stolen goods were later recovered from the house of the accused. He went there with police. PW1, my lord. PW2, my lord, Srimati Popi Gondhia deposed that when she entered into the house of PW1 in the night, she saw the back door open and the wall of the kitchen open. When she went to her room, she found the VIP and other things and utensils missing. The stolen articles were later found
What
in
is
the house of
Sarufa?
accused.
What is Sarufa? Safura or Sarufa?
Pofura. Pofura means petal or petal.
Okay.
PW3, my lord, Sri Jiten Gondhia deposed that while he went in search of his cow, and he found a covering of a sofura and informed the police. Thereafter, police came and went to the house of the accused and seized the stolen goods on being produced by the accused. PW4, my lord, Sri Nipen Gondhia deposed that he found a sofura and a bangle on the backside on the road of house of the accused. First it was noticed by PW3 and then he also went and after informed the police who recovered stolen goods from the house of the accused in presence of the villagers. BW5, my lord, Sri Fulen Gondhia deposed that when he went to the house of PW1. He saw the bamboo wall open and was also told gold ornaments and utensils were stolen from the house. Police later recovered stolen goods from the house of the accused on being produced by the accused in presence of the villagers. PW6 Sri Govinda Chandra Das is investigating officer. Evidence on record reflects the fact that stolen articles were recovered from the house of the accused on being produced by him in presence of the witnesses just after the next day of the alleged incident. The deposition of PWs in their sheet clearly corroborated the fact that the wall of the house of PW1 was broke open and accused committed theft of the belongings of PW1 and was later recovered by police from his house. PW1 in his cross-examination stated that a part of the sofura was found in the field near the house of accused. PW3 and 4 also in their cross-categorically stated that the stolen goods were recovered from the house of the accused and was identified by the informant, that is PW1. PW5 in his cross-examination stated that he saw the open wall of the kitchen of PW1. PW6, the IU in his testimony also stated that on being told and shown by the accused, he sees some clothes and VIP suitcase from near house of the accused, White Exhibit 3. PW2 also in her testimony deposed that a VIP box was also found missing from their room. The learned defense counsel contended that all the prosecuting witnesses are related witnesses. In my considered view, relative witnesses cannot be termed as an interested witnesses, and to decline to act upon the testimony of relative witness merely because of absence of any other witness to corroborate them in court is to defeat the cause of justice. Moreover, PW3 and PW5 are not related to informant, and they have also clearly deposed both in sheet as well as in the pros that the accused himself produced the stolen goods from his house to the police in presence of the villagers, and the informant identified them. Now, illustration A to section 114 of Evidence Act 1872 clearly speaks that the court may presume that a man who is possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen, unless he can account for in his possession. In this case, the learned defense counsel has failed to rebut the prosecution evidence in his cross-examination in a cogent and convincing manner to warrant a contrary presumption in favor of the accused. That apart, the circumstances which are evident from the evidence on record raises an irresistible inference as the guilt of the accused. After consideration of the entire evidence on record, it is clear that prosecution has been successful in bringing home the accused within the ambit of section 457 C80 IPC to justify a conviction. I therefore hold that accused guilty under section 457 C80 of IPC. Accused is heard on the point of.
All right, now where is the appellate court's judgment? Page.
My lord.
Appellate court's judgment, page.
Appellate court. This is the appellate court.
No, this is not appellate court. This is the judgment of the magistrate, the trial court.
Appellate court judgment on the.
Page number 10 is the judgment of the trial court. Don't mislead the court.
Appellate court.
Page 25.
20 started from 23, my lord.
Come to 25.
Yes. 25, my lord.
Yes.
May I read, my lord?
Yes, read.
Judgment and order. The
You see,
criminality is
I
that-
was at that point asking for the appellate court judgment. You all took me to the trial court judgment, and still you want to, you are making that no, that is the trial court. This is very strange. Very strange. I'll come back in 5 minutes.
ইমান তাড়াতাড়ি আৰু না দৌৰিলে কেছ। কি কৈ থাকে এটা লাইনত জুডিচিয়েল মেজিষ্ট্ৰেট ফাৰ্ষ্ট ক্লাছ গোলাঘাট শ্ৰী কে.এছ. পাঠক on 9/10/2006 in the GR case number 2/2006 under section 457/380 of IPC. A written Izahar exhibit was filed with the OC of Dargaon Police Station on 2/1/2006 by the
Counsel, please come to paragraph 8 because we've already seen the evidence. Come to paragraph 8.
Okay.
Page 27, paragraph 8.
Discussion and decision results thereof. Let me discuss the evidence on record for the purpose of deciding the appeal. PW1 Shri Nikhil Gondhia is the owner of the stolen article and informant of the case. According to his evidence, his dwelling house was made of bamboo during a relevant period, that is on 1/1/2006. While he was absent from his house, the occurrence took place. When he returned to the house, he saw that the lock of the door was intact. And when he, along with his wife, entered into the house, they saw that the joining of the wall of the kitchen was open and the back door of the house was found open. Then his wife entered into her room and found that the golden ornaments, utensils, cash amount of rupees 2,500 were missing. PW2 Srimati Popi Gondhia supported the version of her husband PW1. Immediately after the incident, PW1 Nikhil Gondhia lodged the Ezahar before the police station describing the articles that had been missing from his house. The OC of Dargaon Police Station, on receiving the Ezahar, swung into investigation and recovered all the stolen articles from the house of the accused appellant Probin Gondhia. As shown and led by him, under Exhibit 2, the seizure list in presence of witnesses Jiten Gondhia, PW3, and Ripen Gondhia, PW4. Further, the investigating officer seized on VIP box along with some clothes from the sugar cane field under Exhibit 3. The seizure list, as shown and led by the accused appellant in presence of the aforesaid witnesses on 2/1/2006. PW3 Jiten Gondhia, PW4 Nipen Gondhia, and PW5 Kulen Gondhia have supported the prosecution case. The evidence of all the witnesses have not been rebutted during the cross-examination. PW6 Shri Govind Chandra Das, the investigating officer in this case, on being disclosed and shown by the accused appellant, seized the stolen ornaments, utensils, some clothes, including one VIP box from the house of the accused appellant, White Exhibit 2, and from sugar cane filed under Exhibit 3, the seizure list. The learned trial court observed that the prosecution witness are related witnesses. The learned trial court has rightly held that relative witness cannot be termed as interested witnesses, and reliance can be placed on their testimonies without corroboration from the other witnesses. The learned trial court has found that PW3 and PW4 are not related to the informant, and that accused appellant himself produced the stolen articles from his house to the police in presence of villagers on identification of the informant. The learned trial court has rightly observed the fact which is quoted below. Now, illustration A to section 114 of Evidence Act 1872 clearly speaks that the court may presume that a man who is in possession of stolen goods soon after the theft is either the thief or has recovered the goods knowing them to be stolen, unless he can account for his possession. In this case, the learned defense counsel has failed to rebut the prosecution evidence in his cross-examination in a cogent and convincing manner to warrant a contrary presumption in favor of the accused. The learned trial court has rightly held that the prosecution has been successful in bringing home the charge under section 457 and 380 IPC against the accused appellant. I find nothing to interfere with the finding of the learned trial court. While sentencing the accused appellant, the learned trial court has heard the accused appellant on the point of sentence which he expected to receive. The learned trial court has rightly declined to extend the benefit of probation to the accused appellant. The accused appellant was convicted under section 457 380 IPC. The learned trial court sentenced the accused appellant to undergo rigorous imprisonment of 2 years with fine of rupees 300 under section 457 IPC and another 3 years with fine of rupees 500 under section 380 IPC. According to my considered opinion, this sentence is imposed to the accused appellant under section 380 IPC is too harsh. Therefore, sentence as imposed by the learned trial court to the accused appellant under section 380 IPC is modified and sentence the accused appellant Probin Gondhia to undergo rigorous imprisonment for 2 years with fine of rupees 300 and in default of payment of fine as imposed under section 457 and 380 IPC.
Yes, what is the error committed by the appellate court? What is the manifest error? What law has been ignored by the appellate court? You are before a revisional court. Revisional court cannot reappreciate the evidence until and unless you point out that an error has been committed.
My lord, one thing, my lord.
What is the error?
Before, my lord, so far we think, my lord, we presume that the section 27 as the of Evidence Act, my lord, there is a provision that who leaded by the accused persons, the articles were recovered from the house of the accused persons. And some part of the articles were found outside the house in a field, my lord. My lord, in case of articles, whatever as leaded by the accused person were recovered, to that effect there is no statement. As far as
the witnesses, as I have pointed out, this court cannot go into the sufficiency of the evidence given by the witnesses. That stage is over. Now you are before the revisional. Now it is apparent that there are evidence.
This is
whether sufficient, not sufficient, this court will not go into it. And it appears that the police officer in his evidence have also stated, and
Yes.
2 independent witnesses who were the witnesses to the seizure have also said that it is the accused who produced the stolen articles.
Yes.
And it was recovered from the house of the accused. Nothing. There is nothing in this case. There's no error. The appellate court has rightly upheld the judgment of the trial court. And the appellate court has also considered and modified the 3 years imposed under 380 to 2 years. Nothing is wrong. Nothing is wrong.
My lord, I use evidence, we have, I use evidence, my lord, in this case, my lord, investigating officer. Shri Govindra Chandra Das. I am reading, my lord, cross portion, my lord, as of evidence.
How will this court go into the evidence at this stage? This is a revisional court.
Yes, yes. my lord,
From the
revisional
judgment, you
court,
have to point it out.
But
What is the error from the judgment?
As at the instance of accused persons article have been recovered, there must be some statement on the statement should be recorded
Yes, it is
by the
there.
IO, my lord.
IO is already said in the appellate court judgment, page 27, PW6, Sri Gobind Chandra Das, the investigating officer in this case, on being disclosed and shown by the accused appellant, seized the stolen ornaments, utensils, some clothes, including one VIP box from the house of the accused appellant, and Exhibit 2 from the sugarcane field under Exhibit 3, the Caesar list. What more? The IO needs to tell. And PW 3 and 4 who have supported the prosecution case. They have already said that in the presence of the OC of so and so, sorry. Yes, they have also said.
My lord, evidence disclosed of IO, my lord, like this, my lord, in Assamese.
Cross-examination is different. First, in examination, what has he said? He has clearly said that he has that these are found upon being disclosed by the accused.
Cross-examination like this, my lord. Just a minute, my lord, I am reading.
Okay, read.
For your kind information, my lord. কুকুৰা উদ্ধাৰ কৰাৰ পিছত পদুতীয়া ঘৰলৈ যাওঁ কুকুৰা পোৱাত ঠাই বুলি that is cross examination ঠাই বুলি আসামীৰ ঘৰ আছিল বস্তুবোৰ উদ্ধাৰ কৰাৰ লগতে আসামীৰ কোনো ষ্টেটমেন্ট লোৱা হোৱা নাই
It's okay. There was no statement. That statement was taken later on, but at that time he produced it. He had produced it. What is wrong in that? He at the time of production, not necessarily his statement has to be recorded. It will be obviously the IO will first recover the articles and then then the interrogations will start. The statements will be recorded. Sorry. Yes, Mr. Thakur.
Otherwise, there is not, the learned appellate court has rightly upheld the order. There are 6 prosecution witnesses, my lord. My lord, 3, 4, and 5 supported the prosecution case. And my lord, thereafter, immediately on the next day itself, my lord, stolen articles were immediately on the next day of the incident, those stolen articles were recovered from the house of the petitioner and one another seizure list Exhibit 3, my lord. Those articles were also recovered from the sugarcane field of the appellant. And my lord, these, my lord, thereafter, my lord, on the basis of those evidences, Learned Trial Court has rightly, my lord, convicted the petitioner under those sections, and thereafter, all those materials were also discussed by the Learned Appellate Court. Appellate Court has also rightly upheld the conviction and sentence passed by the trial court. And my lord, moreover, the Appellate Court also considering the, my lord, sentences to be harsh, my lord. In fact, my lord, reduced the sentence up to 2 years. So, my lord, from the evidences on record, there is nothing to interfere, my lord, in the judgment of the Appellate Court, my lord, at this stage.
Evidence at consult.
And where from those stolen articles were my lord, recovered from, after recovery, the petitioner has not, appellant has failed to explain anything regarding those. So, my lord, presumption definitely.
In this
goes-
313, what did the accused say?
My lord, accused statement under recorded under section 313 statement, my lord.
Yes. Just have a look. What is his explanation there?
Not only, my lord, explanation is not only sufficient, my lord. If those stolen articles were recovered from the possession of the appellant, you will have to prove by way of citing evidence that yes.
Yes, yes, but what is the statement? In 313?
I am trying to find out the 313 statement. Okay.
Did the defense lead any witness?
No, man. No.
Did you get the 313?
Yes, 313 statement, he has my lord, stated nothing, my lord. All those. some
Mere
quick-
denial?
Yes, ma'am.
No explanation?
No explanation.
So?
Not true, my lord, but no, that is
Hmm?
only, but it has been stated.
হয়তো নহয়।
Yes. Otherwise, there is no such explanation while learned trial court put those 6 questions.
এই
Well,
ৰূপক, এইটোত কি কৈছে? এইটো কি কৈছে? No, this is the question. Okay. Pranav, this is item number 17. Heard Mr. N. Ahmed, learned counsel for the petitioner, stop. Also heard Mr. P. Borthakur, learned APP for the state respondent, stop. This appeal is, sorry, by way of this revision petition under section 397 of CRPC 1973, read with section 401, comma, the petitioner is assailing the judgment and order dated 18/4/2012, passed in criminal appeal number 46 of 2006, arising out of GR case number 2 of 2006 by the learned session judge Golaghat, Assam, upholding the conviction and sentence under section 457, 380 of IPC with modification. The sentence passed under section 380 IPC to the extent of 2 years instead of 3 years with fine of rupees 300. Only and in default of payment of fine as imposed under section 457, 380 IPC, the accused appellant shall undergo another simple imprisonment for 10 years and dismiss the appeal. With aforesaid modification of sentence. Full stop. The brief facts of the case is that an FIR was lodged at the on 1/1 on the same date. FIR dated
2/1/2006, on the next day, my lord.
on 2/1/2006, alleging inter alia that the petitioner stroke accused entered into the house of the informant stroke respondent number 2. Respondent? Informant is a respondent here? Informant. By breaking open a wall of the house and stole valuable articles therefrom. Accordingly, the FIR was registered as what? Registered as GR case.
Yes. There was yes, case number 01/2006.
FIR is registered as
Case number.
Deargaon Police Station case number. Case number
Deargaon PS case number 1 of 2006
two.
under section 457/48. Accordingly, investigation was carried out and upon completion, charge sheet was filed against the petitioner and thereafter the Court of Judicial Magistrate First Class, Golaghat, hereinafter referred as to the Magistrate Trial Court, framed charges against the petitioner and conducted the trial. After conclusion of the trial and hearing, the trial court by judgment and order dated 9/10/2006 was pleased to hold the petitioner accused guilty under section 457/380 IPC and accordingly convicted him and sentenced him thereof. Being aggrieved by the aforesaid judgment and order of the trial court, an appeal was preferred before the court of the session judge at Golaghat, hereinafter referred to as the appellate court, wherein the appellate court by judgment and order dated 18/4/2012 was pleased to hold that was of the view that there is nothing on the material on record requiring interference of the findings of the trial court and accordingly uphold the judgment and conviction of the trial court. However, as regards the sentence imposed under section 380 of IPC. The appellate court modified the same to that of 2 years instead of 3 years. Stop. Situated thus, the present revision petition has been filed against the aforesaid judgment in order of the trial court. Stop. Mr. So-and-so, learned counsel for the petitioner, submits that submits that the manner in which the accused have produced the stolen articles in question to the investigating officer is not narrated by the investigating officer in his deposition before the trial court. And hence, the presumption under section 114 ought not have been drawn against the petitioner, for which the appellate court, for which the judgment and findings of the appellate court suffers from legal infirmities. Stop. Or from which for which the appellate court has committed legal infirmities. Stop. Per contra, Mr. P. Borthako, learned APP for the state respondent, submits that the judgment in order of the appellate court being based on appreciation and reappreciation of the evidence and as per the provision and the same suffers on the basis of the evidence of the prosecution and the same suffers from no legal infirmities whatsoever. He accordingly submits that the appeal file, he accordingly submits that the instant revision petition is liable to be dismissed. Stop. Heard, perused. Stop. It appears that the prosecution has adduced evidence of 6 prosecution witnesses, including the investigation officer as PW6, whereas the case of the petitioner is complete denial in his 313 statement and has not led any defense witness and chose not to lead any defense witness, adduce defense witness. Stop. It appears that it appears from the evidence of the investigating officer, PW6, supported by the 2 witnesses of the Caesar, PW3 and Caesar witnesses are 4 and 5, na? Yes. PW4 and 5, that the evidence that the accused had produced the stolen articles from his house in the presence of the villagers. Stop. It further appears that PW1 and PW2, from whose house the articles in question was alleged to have been stolen by the petitioner has also deposed that while they entered the that while they returned back to their home, they found that few articles that the listed articles were missing from their house, and the door and the kitchen and the walls of the kitchen, which is made of bamboo, was open. It appears that based on the aforesaid evidences, the trial court convicted the accused petitioner under section 380 under section 457 380 IPC and sentenced him thereof. Relevant portion of the judgment and order of the trial court reads as hereunder, page 12, A to A. It appears that the trial court, after appreciating the said evidences, was of the clear view that was pleased to dismiss the appeal. Was pleased to dismiss the appeal. Stop. Relevant paragraphs of the judgment and order of the appellate court reads as hereunder. A to A. Page 27. Page 27 and 29. It appears that the appellate court has a reading of the aforesaid judgment of the appellate court. It is apparent that the appellate court, upon after appreciating the evidences on record, was pleased to uphold the conviction and a conviction of the trial court. Conviction of the trial court. Or uphold the judgment and order of the trial court. It further appears that the trial court section 114 illustration A is reproduced hereunder for ready reference. It is apparent in the reading of the aforesaid section, section 114 of the Indian Evidence Act, reads as an illustration. Reading of the aforesaid, it is apparent that a court may legitimately draw a presumption not only of the fact that the person in whose possession the stolen articles were found committed the theft, but also that he committed the murder. Undoubtedly, the presumption is rebuttable. However, no, is rebuttable, and heavy burden lies on the person on the accused to account for his possession. Not heavy burden, to explain, to account, to account for his possession. Stop. In the instant case, firstly, in the instant case, there is no such circumstances which weakens the case, weakens the presumption which can be drawn under section 114 of the Evidence Act on the account of the stolen articles in question being recovered from the house of the accused on being produced by the accused. That apart, it appears that the petitioner has not explained as regard how the stolen goods was possessed from his, was in his possession in his house in his explanation, in his examination under section 313 CRPC. In fact, he has generally denied all the incriminating statements by saying, quote unquote, it is not true. Correct, Mr. Bhattacharya? Hoyto nohoy?
Yes.
Further, it appears that the accused has also chose not to adduce any defense witnesses. Stop. In such circumstances, the presumption under section 114 cannot be ignored by the court. That being so, this court finds no legal infirmities whatsoever in the judgment and order of the appellate court. Accordingly, the revision petition stands dismissed, no cost.
Martin.
Item number 14.
May I please, Your Lord?
Yes, Mr.
My Lord,
Biswas.
we have challenged this in revision, the instant CR case pending in the court below, under section 498A, it was filed by the wife against the mother-in-law, father-in-law, and the son, husband. So, my Lord, though process was, service is completed, they did not turn up.
There is an order of this court? Yes, huh?
Office note indicate the service is completed.
Service is deemed to be completed, it is written also because Lordship, it
And
is return unserved Lordship.
And there is an order of this court 7/11/13. The petitioner shall take steps on or before and on their that is different.
So, my Lord,
And in 4/5/16 it says notice is deemed to have been served. Yes.
now I have no knowledge because there was the stay order. So whether it was court below case is proceeded or naturally it is
All
no,
right, you
it is
find
no more
out.
in existence, this case. The 13 years cannot be extended.
You find out. You
But
obtain
I-
instruction.
The person has
Mr.
got
Lawker,
to deliver.
you
I have
also
to write a
try.
letter to them.
Apart from that, Lordship, LCR was, LCR is not available with this case, Lordship.
LCR was not called for, that is the problem.
That is required, Lordship, if it continues, Lordship.
No,
because,
but
Lordship,
why don't you first find out the status of the case? If the case is already over, then why to call for the TCR?
My Lord, if you lordship call for the case, LCR, I think there will be report that this case is no more.
or if registry
Yes.
calls for a
It
status
is
report.
submitted at the bar that the TCR of the that the TCR concerned that the TCR that the TCR of the which case?
CR case number, my Lord. CR case of 1137 to 12012 under 498A.
1137.
1137.
That the TCR relating to Gwalpara and relating to CR case number 1137 of 2012
Pending in the court of.
pending before the learned Munsif number 1 Gwalpara
Yes.
is essential for effective disposal of the instant revision petition. Stop. Let the TCR be called for through the registry
Along with a proper present status report.
along with the present status of the said this is what present status of the
CR case number 11.
present status of the case.
Yes, that will do.
Relist
After 2 weeks, Lordship.
after
After
Bihu.
Bihu, madam, after Bihu.
Lordship. On 23rd, Lordship.
All right.
That is at 4.
24th.
You'll be available, Mr. Biswas?
Yes, sir. I'll arrange.
আৰু এটা যে আমি টাইমিং কৰি থৈছিলো সেইটো কি হয়? Huh?
In this matter, Lordship, the other side, I mean, the accused person already expired, Lordship. And on last occasion, your Lordship direct us to bring the status of the property which is under question, Lordship. That is a quarter, Lordship. Now that instruction is awaited. I am just preparing for some time, Lordship.
All right. Mr.
M.M. Zaman, Lordship,
M.M. Jaman,
on behalf of S. Samaria.
Learned Counsel appearing on behalf of Mr. S. Samaria, Learned Counsel for the petitioner seeks further time to place the instruction as called for earlier by this court by order dated 4/3/2025.
Lordship.
Prayer is allowed. Relist after Bihu. Date. তুমি সব কালে তোমাৰ লগত কাম কৰিব আকৌ মাতি দিব নেক্সট
May I please, Your Lordship? Matter may be fixed at 2. My senior is on next.
Scan copy of case records are available.
Yes, but 23.
It appears that the scan copy of the case records called for is available. relist for hearing. Yes, when?
25
After Bihu?
Before Bihu, did you have on such and such day?
Oblige.
Yes.
Yes. Yes, Lordship, I am petitioner, Lordship.
Who is appearing for the respondent number 2?
Yeah, Lordship, we had a formal party. It is NI case, Lordship.
That's why. Who is appearing for respondent number 2?
Achilles Inamuddin.
Heard Mr. Dide?
Yes, Lordship.
Learned counsel appearing for the petitioner. Also heard Mr. So-and-so Locker, learned APP for the state respondent. It appears that none has appeared for the respondent number 2 on call. It appears that on the last occasion, I-25/9/2020 also, there was no representation on behalf of respondent number 2. Be it as it may, relist after Bihu date Giga on such and such date. Stop. Let registry intimate the next date of listing to the learned counsels appearing for respondent number 2. Next, Matak. 25 of around 9 ki. 12 ahi paisa.
Number 21.
Your Lordship, the matter has been settled, Your Lordship. This is a affidavit shown by both the parties. Your Lordship.
Settled.
Yes.
Yeah, this is the payment.
Heard MS?
S. Nazneen, Your Lordship.
S?
Nazneen.
As Nazneen, learned counsel for the petitioner. Also heard Mr.
S.A. Bakhtiar.
S.A. Bakhtiar, learned counsel for the respondent number.
Respondent.
For the sole respondent.
Sole
Sole respondent. So, it appears that by order that on 18/3/2025, a submission was made at the bar that though payments have been made, however, the documents reflecting the same was not available with the learned counsel appearing for the petitioner. Accordingly, the matter was posted today. Today, when the matter was called, MS
S. Nazneen.
S. So-and-so, learned counsel for the petitioner, has produced a copy of an affidavit sworn by Hirendranath is the
Respondent, sole respondent.
by the sole respondent.
And the petition.
Affidavit jointly filed by the respondent and the petitioner.
Or an affidavit jointly filed by the petitioner and the respondent, indicating that they have amicably settled the NI case and the payments. Where is it said that payments have been also made?
Payment, the amount is not mentioned, Your Lordship, but at clause number 5, Your Lordship, the above noted cases has been settled amicably and suitably by way of compromise.
Okay, stop. Perusal of the relevant paragraph of the affidavit indicates, no, reads as hereunder. Not, don't say perusal. Huh? So and so affidavit reads as hereunder. The quote unquote kori diba page A pra, sorry, page 2 pra. Moito original hoy karone mark kori diya right. Gutei tue di diba. Perusal of the aforesaid affidavit indicates that the parties have amicably settled the NI case in
68 of
question. And learned counsels appearing for both the parties have also conceded to the same. That being so, nothing survives for adjudication in this criminal revision petition. Accordingly, the criminal revision petition stands dismissed on being infructuous.
That's it.
Any further observation is required?
No, that's it.
What happens to the judgment?
Yes, your lordship, the enact matter, your lordship, since he is convicted, lordship, maybe he may be acquitted, your lordship.
Lordship.
What will happen to that? Mr. Sharma? Here, the conviction of the NI court is under challenge, but they both says they have compromised it. And the payment, I think, is also made.
Maybe acquitted, your lordship.
It appears that the have you received the payment?
We have received the payment.
Yeah, Mr. So-and-so, learned counsel appearing for the respondent has further submitted that the payment of the dishonored check has already been returned by the has also been paid by the petitioner pursuant to the amicable settlement arrived between the parties. Stop. That being so, in the interest of justice, the judgment and order dated 25/6/2018 passed by the learned session judge Borpeta in criminal appeal number 3 of 2018 in NI Act case number 68 of 2016, dismissing the appeal and thereby upholding the conviction of the accused petitioner is hereby and also I think that case also
And
the trial court order. What is the case number? Trial court.
Here case number 68/16.
And the and the judgment and order of the trial court dated 14/12/2017 in NI case number 68 of 2016 hereby is kept in abeyance. This hereby set aside.
Set aside.
Set aside.
Set aside.
Yes.
Okay.
Oblige.
Much obliged.
And the affidavit may be kept in record, your lordship. The affidavit may be
Sorry.
kept.
Affidavit to so-and-so kept on record and marked as X.
Oblige.
Original.
Yes.
Much obliged.
Do you want to take back the original and give a photocopy? Original to it?
I have kept the photocopy, your lordship.
Original copy, huh? Upar to original liquid.
Much obliged.
Yes.
In this case, I wanted to bring that IA, my lord. But there is some defect, my lord. I could not serve it to the respondent. Today also, counsel for the respondent absent, my lord.
It appears that an IA has been filed in the instant criminal petition.
Yes, we filing number, I
However,
can
the
keep filing
same is
number.
not on record. Let registry verify and place the same on record. Relist when?
After Bihu, my lord.
Date of the deduct.
Along with the IA, my lord. Oblige.
Registry
But his
verify-
absence may be recorded. His absence may be recorded, my lord. Respondent, counsel for respondent 2 is absent. That may be recorded.
Mr. Your name?
S. Mukhtar, my lord.
Mr. S. Mukhtar, learned counsel appears
Petitioner.
on behalf of the
Petitioner. I am for petitioner.
petitioner. None appears for the respondent on
2,
call.
my lord.
Or for respondent number 2 on call.
All along, we could not serve him copy, my lord. That is the defect, my lord.
That's all right. You make an affidavit
That
to
is-
that
that I will
effect
do now, my
and
lord.
you give it to the
Yes, yes,
registry.
yes, my lord.
How can this court?
Yes, sir. Registrar said today, but let the court say something, then I will do it, my lord.
Mr. So-and-so also submits before this court that despite all attempts,
Yes, ma'am.
he is unable to serve a copy of the
IA, ma'am.
IA to the learned counsel appearing for the petition.
Respondent number 2.
Respondent number 2.
2, my lord. Oblige, my lord.
My lord, item number 27.
Yes.
My lord, I unable to contact with my client.
When
So
do you want it?
whether the maintenance is paying or not, that is not.
As per my information, your lordship, the maintenance has not been paid, but I have not been able to contact my client today.
All right, then you both obtain instructions. All right. Heard Mr. I.A. Talukdar
Yes, for the petition.
and learned counsel appearing for the petitioner and Mr. T. Deori, learned counsel appearing for the respondent number two. It is submitted at the bar that the learned counsels are not unable to contact the clients and ascertain the status of the payment of the maintenance.
Yes, sir.
And accordingly seeks accommodation in the jointly seeks accommodation in the matter. Prayer is allowed. Relist. Relist. They did it. Yes. Item 28. Who is appearing?
Very grateful, Your Lordship.
Yes.
In this case, my lord,
28 fine.
the present FIR was lost by the informant respondent number 2 here in my lord. Due to some continuance of civil proceeding and matrimonial suit between the parties, informant and the present petitioner. So in the meantime, my lord, cognizance has been taken. So we have challenged before this honorable court the side cognizance. So in the last month, my lord, it was the issue between the main issue of divorce has been settled between the parties. And a certified copy of the said civil dispute has been also laid before your lordship for just perusal. So now the fact is that trial of the as per order of this honorable court on previous proceeding, the trial court has been directed not to pass appropriate order, but to continue with the trial, take evidence. So, this appropriate order from this honorable court is necessary. On merit. So,
Have you filed any application?
What kind of application, my lord?
What ordered you? Because this is a criminal petition.
Yes, madam.
You are challenging.
We are challenging the on merit. On merit, my lord, we are challenging the cognizance of the
Alright,
lord.
now if you want some
Appropriate order.
appropriate order, then there has to be an IA.
Appropriate order.
You look into it. I am adjourning it. If anything is to be filed, you file it.
Lordship, you kindly peruse it and give me some suggestion for some time.
This court is not here to suggest to you, Mr. Counsel. It is for you to look into it. In item number 28, you are Mr. Paul.
Yes, my lord.
28.
Yes, madam.
Heard Mr. J. Paul. Stop. None appears for the respondent on call. Heard Mr. I also heard Mr. Lawford and
Yes, ma'am.
APP for the state response.
I am A. Paul, my lord. A. Paul.
A. Paul, huh?
They may bring these documents by way of filing an affidavit, lordship, so that
No, let them file that whatever is to be done. I'm not saying anything today. Let him examine it because you see, this is a criminal petition and he's seeking for a setting aside and quashing of a particular order, right? That apart, what can be given in this petition? Now, if they want some specific something that has to be brought on record by way of an appropriate application, unless that is brought on record, how the court is going to pass an appropriate
Respondent
order?
number 2 may be directed to on the next date.
As prayed for, relist after 2 weeks on a date to be fixed by the registry. In the meantime, the parties are at liberty to bring on record the development which is which is claimed to have happened in the meantime.
otherwise, lordship, this petition has been filed by them. Lordship.
Yes.
So
if
they have to bring
they-
it.
Because there is
Or
bar,
they can withdraw the petition being as it is infractious. Lordship.
Petitioner, petitioner is director. Yes, I better থাকি গ'ল নেকি? Yeah. Call it out. None appears for the appellant despite the matter being called twice. Relist, APP, Mr. Sharma. Relist Bihur আগত বা বিহুৰ পিছত দিদিয়ক এটা date. Next to মাতি দিয়ক.
May I take the paper book, my lord, item number 12?
In that you say the registry, you will take it or registry?
My lord, one copy is there, my lord.
Acha, take it. Video. Next. None appears for the petitioner on call despite the matter being called out twice. Despite the matter being called out at the expiry of the list. A second time at the expiry of the list. Mr. Locker for the respondent. Relist Friday in the order column with the remark for dismissal.
May I please, your lordship? I'm sorry for mentioning this, lordship. I was for item number 24, lordship. I was in like in another.
24 dia hol na order?
Just name may be different.